direct you can do that at this time.
Detective, I think when we left off, we were speaking about the autopsy of J.J. Daybell, correct?
Correct.
You had mentioned earlier that you did observe the actual, not only the body, but then the autopsy of J.J. Daybell.
That's correct.
And were you present for that entire autopsy?
Yes, I was.
And when that autopsy was concluded, what did you do?
At that time, Dr. Warren and his team removed JJ from that autopsy table. Then they brought out a second, excuse me, black body bag. And I recognized it to be the same body bag from the scene because it also had dirt. And they placed that body bag on the table.
And what did you observe next?
Dr. Warren and his team opened the body bag, looked at the remains for what was left as far as remains inside. He stated there was nothing he could do at that time with an autopsy. So
Judge, I'm going to move to strike as hearsay,
Your Honor, statement already came through.
and I'm going to move to strike. So,
could you repeat the question?
What did you observe? What were you had just talked about the Ty's remains being brought out. What did you observe?
Once the remains were brought out, Dr. Warren opened the bag and looked at the remains and stated there was nothing he could do at that point. So at that time, we left the autopsy room for the day.
And when you left, did you do anything in furtherance of your investigation that day?
No,
Did you return to the Ada County Coroner's office the next day?
we did. On June 12th, 2020, we went back to the Ada County Coroner's office. At that point, Lieutenant Ball took custody of some of the evidence and we transported it to the state lab in Meridian.
And were you with Lieutenant Ball when you did that?
I was, yes.
And once you took it to the state lab, what did you do?
Those items were checked into the state lab. And then that concluded what we did for that day.
Detective, you spoke earlier about some of the other agencies you've worked with in this investigation. And is it correct you worked with Fremont County?
Correct, yes.
And I believe you testified that your primary focus in this investigation was looking for Tylee and JJ. Is that accurate?
Yes, that's accurate.
Was there an investigation in Fremont County at the same time that had connections to your investigation?
Yes, there was.
What was that investigation?
Fremont was investigating the death of Tammy Daybell, who was married to the defendant, Chad Daybell. Kind of the exact same time we were doing our investigation with missing children.
And would you meet with Fremont County and discuss the cases together?
Yes, we would.
And would you aid each other in those investigations?
Yes,
Would you share information?
yes.
Detective, are you aware of any event involving Tammy Daybell on October 9th, 2019?
Yes, I am.
How did you become aware of that event?
Through the course of sharing information with the Fremont County Sheriff's Office. We were advised,
Judge, can we approach?
yes.
I want to have the court reporter, if we could, read back Mr. Wood's previous question before the sidebar, and then I'll see if there's an objection held by defense.
Question, how did you become aware of that event?
Is there an objection to that, Mr. Pryor?
No, not to that question.
Okay, then Mr. Wood, just proceed with another question.
I don't think there's no objection to the question. I don't think it's been answered yet.
Okay. You can answer.
We were advised through the course of our investigation that
Judge, I'm going to object at this point. The question is whether he was advised, not what he was advised of, but whether he was advised.
Our response, Mr. Wood?
I'm not quite sure I understand that objection, Your Honor.
I don't as well, so you can continue with your response.
Can you repeat the question, please?
How did you become aware of the events of October 9th, 2019?
Through the course of our investigation, we were aware of those events through speaking with Fremont County Sheriff's Office.
Why was it important to you in investigating your case to share information and receive information from Fremont County?
It was important because the suspects in that case were the exact same suspects in our case. And so we wanted to make sure that we shared information so nothing was missed. At that point, we were still looking for two small children. And so it was imperative to us that we shared information and gathered information from neighboring counties and anybody that was involved with this case.
And did you also confer with Arizona law enforcement?
We did, yes.
Detective, are you aware of who Charles Vallow was?
Yes.
Who was he?
Charles Vallow was married to Lori Vallow.
Is he alive?
No, he is not.
Do you know when he died?
Charles died July 11th, 2019.
Are you aware of how he died?
Charles was shot by Alex Cox, Lori's brother.
Now, you testified earlier that your initial involvement in this case involved looking for a Jeep.
That's correct.
And I believe, correct me if I'm wrong, I believe you testified that you were looking for that Jeep because it was requested by Arizona law enforcement.
That's correct, yes.
And are you aware of why they were looking for that Jeep?
Yes, I am.
Why were they looking for that Jeep?
That Jeep was a suspect in an attempted homicide of Brandon Boudreaux, who was married to Lori's niece, Melanie Boudreaux. The suspect in that homicide was also Alex Cox.
Detective, going back to October 9th, 2019, Tammy Daybell, are you aware of the incident that took place with Tammy Daybell?
Yes, I am.
What was it?
Judge, I'm going to object. There's no foundation as to how you became aware of it.
Sustained.
Through your investigation, did you become aware of what happened with Tammy Daybell?
Yes, I did.
And how did you become aware of that information?
Sharing information with Fremont County.
And so was this part of the collective knowledge of the case that you were working?
That's correct, yes.
And did you aid in that investigation as well?
I did.
So you personally became aware of these events?
Correct.
Based on your knowledge and your investigation, are you aware of any event involving Tammy Daybell on October 9th, 2018?
Judge, again, there hasn't been proper foundation.
I think at this point I've established that it's through his investigation and knowledge. Your Honor.
This objection's overruled.
You can answer the question.
Yes, I'm aware.
And what was that event?
On October 9th, 2019, Tammy Daybell believes that she was shot at in the driveway of the defendant Daybell's residence.
And when you say shot at, are you aware of how she thought she was shot at?
She initially reported that it was possibly a paintball gun.
Detective, in your investigation, did you ever put together timelines of events that took place?
Yes, I did.
Why is it important to do that?
Just to establish who the key figures were and the key dates to aid in our investigation, so we can make sure that we share the accurate and correct information with the other agencies.
And in preparing for this trial, did you prepare any charts of key figures to aid the jury in understanding your testimony and the testimony in the trial?
Yes, I did.
And was that based on your involvement in the case
Yes,
and your investigation?
correct.
And based on I'm sorry, that wasn't very well said. Based on the information you gained from your investigation.
That's correct.
Your Honor, I'd ask that the witness be handed State's Exhibit 30. Detective, do you have State's Exhibit 30 in your hand?
Yes, I do.
What does it purport to be?
Those are the key figures that I put together as far as the investigation goes, photographs.
And did you do that to aid this jury in understanding who the people involved in this case are?
Yes,
And did you do that in anticipation of your testimony?
yes, I did.
Right. And are those, the pictures attached with those names, are those true and accurate representations of the individuals attached to those names?
Yes, they are.
Your Honor, for demonstrative purposes only, the state would move to enter State's Exhibit 30 into evidence.
Any objection?
For demonstrative purposes, no.
Very well. Exhibit 30 is entered for that reason.
May I publish?
Yes.
Detective, if you can just use your pointer and just, for purposes of the record, read the names attached with each picture.
Sure. This is Lori Vallow Daybell, Charles Vallow, Alex Cox, who was Lori's brother. Chad Daybell. Tammy Daybell, his deceased wife. Tylee Ryan, who is daughter to Lori. JJ Vallow, who's a son to Lori. And Melanie Pulowski Boudreaux, she was remarried, is the niece to Lori Vallow.
And when you say that JJ was Lori Daybell's son, was he also Charles Dowell's son?
Yes, he was.
And that was by way of adoption, correct?
That's correct.
And so Alex Cox was JJ and Tylee's uncle.
Yes.
Detective, similar to that last chart, did you prepare a timeline in anticipation of your testimony?
Yes, I did.
And did you do that based on your experience and knowledge of the case?
Yes, I did.
And it was based on information you gained through your investigation?
That's correct.
And did you do that to aid the jurors in understanding just the basic timeline of the events that happened in this case?
Yes.
Your Honor, I'd ask the witness be handed State's Exhibit 31.
Judge, could we approach please for the sidebar?
Yes.
This time, ladies and gentlemen of the jury, there's an evidentiary issue to resolve, which we are going to take up outside of the presence of the jury. We'll do that as quickly as we can. So I will be out the bench while I research this momentarily, then we'll come back on and make a ruling outside of the jury's presence, bring them back in and continue evidence.
All rise, please. May be seated. Court hearing session.
Thank you. Please be seated. All right, we are back on the record on CR 2221-1623. We are going to take up an objection outside of the presence of the jury as it relates to the state's proposed exhibit, in this case particularly state's proposed exhibit 31. And the court had to go back and review some prior rulings in the case that occurred some time ago. I've done that now, so what I'd like to go through is the proffer and determination if there's still a objection to the exhibit and make a ruling on that outside of the jury's presence. So Mr. Wood has offered exhibit 31, which is a timeline, and Mr. Pryor, does the defense maintain an objection to the admission of that timeline?
Judge, I spoke with Ms. Blake.
I spoke with Ms. Blake, and procedurally, I think at the time that the 404B was filed by the state, we were also dealing with the severance issue, is what I recall. And then she discussed that with me. So I think I may have made a non-objection to the 404B. And I think I made a record of that when Mr. Thomas and Mr. Archibald were objecting to that. So I may forego my objection because I think my recollection is I don't have a record of it, Judge, which is a little unusual, but I think I may have noted on the record to the court that I'm not objecting to the introduction of the 404B evidence.
All right, I understand. I think there was lodged an objection back February 14th of 2023 by you to the 404B motion. Is the state having clarification on that, Mr. Wood?
Your Honor, just based on recollection, I believe it was not an objection to all of the state's intended 404B, but some of it. And my recollection, and I'm not looking at any document, this is just my recollection, was that the defendant did stipulate to some of the 404B, including issues dealing with Charles Fallow and Brandon Boudreaux. That's my recollection.
And Judge, my recollection is that I did file a timely objection, but then at the hearing, there was, and I'm going back, Judge, and we're talking 3 years ago, and I'm just going off of recollection as well, as Mr. Wood is. I believe that I filed an objection, and then at the time of the hearing, I may have orally stated that I'm not objecting to the introduction of the Brandon Boudreaux or the Charles Fallow information, and Mr. Thomas and Mr. Archibald continued theirs, and the hearing was continued on, and somewhere in the interim, Judge, there was a severance order granted, and I don't know whether I was part of the 404B motion. That's where I'm having some difficulty in recollection. My records don't show an order that you granted the 404B in this case, so I don't see an order in this case.
Okay, so just to clarify, there was an objection was filed on behalf of Mr. Daybell by Mr. Pryor, February 14th, 2023 to the 404B. We then had a hearing on the 404B evidence on February 22nd, 2023. The court then issued an oral ruling on the record, and in that oral ruling went through different evidence that was sought to be proffered under 404B. And among the rulings the court made on the court minutes under paragraph 9, specifically referencing consideration of the shooting at Mr. Boudreaux, the court weighed out the 404B arguments and found that it would be admissible at trial. And then in the hearing, I did indicate that I'd gone through the analysis for 404B, looking at the State versus Fox case, doing a two-tiered weighing of the factors, balancing them out with the evidence proffered, and ultimately, and I'm looking at the transcript of this hearing where I made the oral ruling, determining finally, quote, the court does find there is relevance under tier 1, parts 1 and 2 for the introduction of that evidence. And then I looked at rule 403 to see if there was probative value to substantially outweigh the danger of unfair prejudice, and finally determined that as to the attempted shooting of Brandon Boudreaux, there would be more probative than unfairly prejudicial, as it would relate back to the purported plan of the defendants. So the court did find that the state was permitted to introduce that 404B evidence. So as we stand here, knowing procedurally that's the ruling, on the timeline, I guess I'll first come back to this proposed Exhibit 31 and ask if there's any objection at this point for the defense, Mr. Pryor.
No, Judge.
Okay, so Exhibit 31 then has been offered and will be admitted. I would also note on the record that I think the board has been open to discuss that anyway based on opening argument as well, but for that reason and also based on the court's prior determination made, I am going to permit that reference on 404B evidence. The reason I'm still discussing this for counsel is I think this now triggers a requirement that I give a limiting instruction to the jurors about how 404B evidence is considered. And I do have prepared a limiting instruction that I am going to advise them of at such point as after your exhibit's been offered, Mr. Wood. Okay. Okay, thanks for the delay there. We could bring the jurors back in, please. This is,
I don't know where the.
I got the actual.
And Judge, if I could just quickly inquire before the jury comes back in, if the court did have both pages of that in its,
I don't, I only have first page.
okay, once we get done with this witness, I'll bring that up.
Okay.
All right. Jury present and counted for.
All right, thank you. Please be seated. All right, ladies and gentlemen of the jury, apologies for that delay. We were working through an evidence issue. I will note that the state has offered Exhibit 31, which has now been admitted by the court. It's a timeline. It does make some references in there that, for me at this time, I think would be best to give the jurors a special limiting instruction. So I'll read this instruction to the jurors at this time. Ladies and gentlemen, during the course of this trial, evidence will be introduced for the purpose of showing that the defendant committed acts other than for which the defendant is on trial. Such evidence, if believed, is not to be considered by you to prove the defendant's character or that the defendant has a disposition to commit crimes. Rather, such evidence may be considered by you only for the limited purpose of proving the defendant's motive, opportunity, intent, plan, or absence of mistake or accident. So with that instruction provided, Mr. Wood, if you'd like to proceed with that exhibit E.
Your Honor, I don't have these.
Well, I believe the witness does.
May I publish?
Yes.
Just briefly before I do, Detective, before we took a break, we spoke about timeline you had prepared.
Correct.
And the reason you prepared that was to aid the jury in understanding the events of this case.
Yes.
If you can take your pointer and go through these events and just read them into the record.
July 11th, 2019, Charles Vallow dies. September 2nd through September 3rd, 2019, Lori, Alex, and the kids, JJ and Tyler, moved to Rexburg, Idaho. The last known proof of life for Tylee was September 8th, 2019. The last known proof of life for JJ was September 22nd, 2019. The attempted shooting at Brenton Boudreaux, Gilbert, Arizona, or attempted homicide, excuse me, October 2nd, 2019. The attempted shooting of Tammy Daybell, October 9th, 2019. The death of Tammy Daybell, October 19th, 2019.
And if you'll continue on the second page.
November 1st, police receive a call about a Jeep. The Jeep was located November 4th, 2019. Chad and Lori get married in Hawaii, November 5th, 2019. Welfare check on JJ, November 26th, 2019, which is the same day Alex and Chad were contacted. The Rexburg Police Department searched Lori and Alex's apartments November 27th, 2019. Search warrant served on the Daybell residence was June 9th on 2020. JJ and Tyler were taken to the Ada County Coroner's office June 10th, 2020. And the autopsy was conducted June 11th of 2020.
Thank you. Your Honor, I have no further questions for this witness at this time.
All right, thank you, Mr. Wood. Mr. Pryor, cross-examination.
Judge, would the court like me to start, or would you, or like to take a break at the lunch break?
Let's go ahead and get started with cross and go till at least 10, please.
Good afternoon, all. Good morning, officer.
Good morning, sir.
We do know each other. We've at least exchanged pleasantries a couple of times
Yes, sir.
in the past. And I guess for purposes of this hearing, would you prefer that I refer to you as lieutenant or officer?
Lieutenant's fine.
Mr. Pryor, Apologize very much for the interruption. I wanted to confirm something on that last exhibit. It was entered by the court. Is that a demonstrative exhibit?
That's what I understood.
Either as a demonstrative or a summary.
Okay, thank you, counsel. Apologies for the interruption.
Judge, I'm also looking for the, oh, I found it. So Lieutenant, you've been involved in a number of aspects in regards to this case, right?
That's correct.
You've done some investigation on your own in terms of the welfare check with Lori Vallow, is that right?
Yes,
But you've also interviewed a number of witnesses, is that correct?
yes,
You interviewed Melanie Gibb, David Warwick, right?
yes,
Several times?
few times.
And you've interviewed a number of other witnesses as it relates to this case, is that correct?
Yes,
Okay, now you previously discussed your role as a police officer and investigator in this case. And I guess I want to clarify something if we could, please. As a police officer investigating a case, your role is to conduct an investigation, right? Look at the facts.
correct,
Try to establish and gain some information, right?
correct,
But you're not supposed to judge one way or the other, right? You're supposed to remain neutral,
that's correct,
and you're not supposed to narrow that role as a police officer to a particular person. Is that correct?
that's correct,
In other words, you're supposed to look at the evidence as a whole. And rather than focusing on one person and saying, we're going to assume this person did this, and we're going to build our case around prosecuting that person, that would be inappropriate, wouldn't it?
Right.
Your role is actually to look at all the evidence, consider all the evidence. And once you've gathered all the evidence that you think is relevant to a case, what do you do with that evidence?
we followed the evidence,
Okay, and then once you follow the evidence, you've established a report or you've come to concluding your investigation, what do you do with that evidence that you've concluded with?
we put a case together,
Okay, and then do you provide it to someone?
we provided to the prosecutors,
Okay, so there's distinct roles as part of a criminal case. You'd agree with that, right?
yes,
And your role is to conduct an investigation, correct?
correct,
Look into all possible evidence of any kind, correct?
that's correct,
And view the evidence, right?
yes,
Not make any determination as to what that evidence means, but rather gather as much evidence as you think is relevant in your mind and put together a compilation of that evidence, correct?
correct,
Okay. And then at that point, only at that point, do you provide it to the prosecuting attorney and they make a determination as to whether or not they will pursue charges against somebody. Do you understand? Is that the way you understand the process is supposed to work?
yes,
Okay. And if you were not to follow that process, if you were not to follow what I just described, that wouldn't be appropriate. There's protocols. You agree with that, right?
yes,
Okay. And you should never blend the roles of a police officer with the role of a prosecuting attorney. You would agree with that, right?
explain what you mean by blend the roles.
Well, I mean, it's not a prosecutor's role to show up at an investigation when you're conducting an investigation and engage in part of the process of interviewing witnesses. You'd agree with that, right?
I've had prosecutors show up to certain investigations.
Okay, but that's not the norm, is it?
I think it depends on the investigation.
Okay, okay. So in other words, you think that it's appropriate that if a prosecutor is deciding whether to pursue charges against somebody, that they should also participate in the interviewing of these witnesses as part of that process. Is that what you're telling me?
I think it's important for a prosecutor to have all the information.
Well, doesn't that create a problem in your mind?
No, sir.
Okay. Well, let me talk to you a little bit about that. Because if you're doing an investigation and you're really remaining neutral as part of that investigation, right? You're not supposed to make judgments, correct?
Correct.
You're supposed to look at the evidence, gather all the evidence, and then make a determination of what evidence you want to submit to a prosecuting attorney, right?
Correct.
Do you ever get involved in the process of deciding whether someone should be charged or not?
What do you mean by that, sir?
Well, after the evidence is all gathered, and after you've done your report as a police officer and put together all of the information, do you ever go over to the prosecutor's office and say, you know what, I put this evidence together, and you know what, I want to have a discussion with you about whether or not we want to charge this person? That wouldn't be appropriate, would it?
I'm gonna object as argumentative.
Sustained.
Okay. But would it be appropriate for a prosecutor to interview witnesses and inject their personal opinion in those processes of interviewing witnesses? Would that be proper under any circumstances?
And I'm gonna object as argumentative.
I'll overrule that objection.
And could you repeat the question again?
Yes. But would it be appropriate for a prosecutor to interview witnesses and inject their personal opinion in those processes of interviewing witnesses? Would that be proper under the circumstances?
To interject their personal opinion?
Yeah.
I would say probably not.
Okay. So if you're engaging in name calling or making references to a person's character in a case, that would clearly be an inappropriate act, would it not?
Objection beyond the scope, Your Honor.
That's sustained, and that's facts, not evidence.
Right. Now, you spoke a little bit about this body cam issue. And you said that it was a policy that there's only one body cam among 7 or 10 of you as detectives. Is that right?
No, sir, I never once said it was policy. I just said there was only one body cam.
Oh, so,
Between 7 detectives.
so in other words, you share a body cam. It's not a policy within the department.
Correct.
Okay, is there a policy in the department about recording or trying to preserve a record when you're interviewing witnesses?
Yes.
Okay, and what's that policy, sir?
When we interview and conduct interviews at the police department.
Yeah.
Those interviews are recorded.
Okay. Now, what about if you're out in the field and you're conducting an interview? Is that to be recorded as well?
There's no policy that says it has to be recorded.
Okay. Do you carry a microphone as well, officer, other than a body cam?
No, not on my person, I don't.
Okay. Do you carry a cell phone while you're doing that? That's issued by the county.
Do I keep the cell phone in my car? Yes.
I didn't ask you that. I said, do you carry a cell phone when you go out in the field?
On my person or in my vehicle?
Either one.
In my vehicle.
Okay. And does that cell phone have the technology that allows you to record or photograph and videotape images?
Yes, it does.
Okay. So what I understand is on November 26, 2019, you were directed your folks to go out to the Lori Vallow residence. Is that right?
That's correct.
Okay, and you said that you were with Ron Ball. Is that who you said you were with?
At one time, yes, I was with a couple different officers that day.
Oh, so tell me who you were with on that day. Remind me.
Detective Dave Holt,
Okay,
Detective David Stubbs,
okay.
and Lieutenant Ron Ball.
So there were 4 of you who went out there to locate or to find out some information about what again? Remind me.
About the whereabouts of J.J. Vallow.
Okay, and this was a concern that you had because you were contacted by another law enforcement agency expressing concern about the safety of a young child, right?
No, sir.
Okay, tell me what was the purpose?
It was a simple welfare check.
Okay. And you went out on this welfare check and there were, if my math is correct, please correct me. Did all 4 of you detectives and lieutenants go out at the same time?
No, sir.
You went out at different times.
Myself and Dave Holt went out initially.
Okay, and then when did the other 2 officers show up?
When I called them based on the lies that I had been told.
Okay. And these lies that you've been told, at that point, you and Detective Hope, neither of you decided to bring a video camera, right?
That's correct.
And neither of you decided to wear a recorder to record any of the incidents that took place about these so-called lies, right?
That's correct.
And nobody took out their phone and recorded it or made a video or audio recording of the discussion with Mr. Daybell or Mr. Cox on November 26, 2019, right?
That's correct.
And even after you said these so-called lies, even after you discovered that, Mr. Daybell apparently told you something that you didn't think was true, at that point, did you instruct any of the officers who were coming to aid you? Maybe it's a good idea we should bring an audio with, or a video camera with us, or a mic to record some of these statements, because I have some concerns. Did you
Objection,
think
that's
about
not a
that?
question.
We did that, sir.
Hold on.
I'm going with that. There was an objection and sustaining the objection. So, strike the answer. You can ask another question, Mr. Pryor.
And it was Detective Stubbs who had the video cam, is that right?
That's correct, sir.
And that was when you video cammed Miss Vallow, about when you had contact eventually with Miss Vallow, is that what the video camera that you're talking about?
I didn't have contact with Miss Vallow.
Now, I'm a little confused about something. And maybe you can clear this up. You said that you asked Mr. Daybell first about whether he had Lori Vallow's phone number, correct?
No, sir, I didn't contact Mr. Daybell till after I contacted Alex Cox.
Okay. At some point, did you ask for Lori Vallow's phone number from Mr. Daybell?
Yes, I did.
Okay. And at no point did you ever make a threat to him saying you're going to turn this phone number over to us, right?
No, sir.
At no point did any other officer walk up to him and say, if you don't turn this phone number over, you're going to get yourself in a lot of trouble. That never took place to your knowledge, right?
That's correct.
Okay. But then after that, you're saying, at first he said, I'm not going to give you the phone number. And then out of the blue, he decides to give you the phone number.
Objection misstates the facts and evidence.
Okay. Then subsequent to that, he
Hold on,
decides,
Mr. Pryor. When there's an objection, I'm gonna rule on it before you launch into another question. So the objection is sustained.
subsequent to that, he decides to give you the phone number. Is that right?
Can you repeat the question, please?
I'll go back over the analysis here.
Thank you.
Your testimony is that Mr. Daybell refused to give you the phone number at first, correct?
That's correct.
And that was an adamant refusal. He said, no, I don't know what her phone number is, right?
That's correct.
And then without any further prompting by the police officers or any encouragement by law enforcement, he shows back up and gives you the phone number later, right?
Objection, he's misstating the facts and the
Well,
evidence.
I'm trying to establish the facts, Judge.
The objection's overruled. If the witness has an answer, you may answer.
You say he showed back up. He never left when I originally asked him.
Okay,
I had to ask him twice to get the phone number.
okay. And how much time passed between the first request and the second request?
Roughly a minute.
Okay. So without any prompting by the police, he asked him for the phone number. He denied, and then within 60 seconds, he said, oh, here's the phone number. Is that what your testimony is?
When Detective Hope started walking towards us and I re-asked him again, that's when he gave me the number.
So you had to ask him twice. Is that what you're saying?
That's correct.
Now I'm gonna kind of bounce around a little bit, okay? Please bear with me, okay? You made a comment about supposed paintball guns, and if I misquote your testimony, please correct me, okay? You said something about a supposed paintball gun incident with Tammy Daybell, right?
Yes.
Okay. And then you later on decided that it was the words you used were a shooting. Is that the word you used?
Probably.
Well, you were just here testifying a few minutes ago, and just used the word shooting when Mr. Wood talked to you about that, right?
Yes.
Okay. Now, as part of your investigation, you got a chance to look at all the evidence, right? In this case, you got access to almost all the evidence in this case,
That's
correct?
correct.
And have you gone through all the evidence in this case?
Yes, I have.
Okay, and did you look at evidence of facts and circumstances surrounding the Tammy Daybell incident on October 9th?
Yes.
Okay. And Judge, just bear with me.
Your Honor, if he's gonna be showing evidence digitally, can we put our screen back up?
Yeah.
Not sure I'm gonna be up there, but okay. Now, I would represent to you that we previously stipulated to the admission of a number of exhibits in this case. And one of the exhibits is exhibit number 16. Okay? And the parties that previously exhibited, Judge, we've already moved it, it's already been exhibited. So what I'm gonna do is show you exhibit 16, okay?
And this is one already admitted.
It's already been admitted, Judge, previously. Now, you talked about facts, and you used the word shooting is what you used, right? With Tammy Daybell?
Right.
And you don't believe that Tammy Daybell was shot at with anything other than a paintball gun, do you?
Objection relevance.
Or
You don't believe that Tammy Daybell was shot with anything other than a paintball gun, do you?
Yes, I do, sir.
Okay, and what do you base that on?
The evidence through our investigation.
Okay, and part of your investigation is did you look at the Tammy Daybell evidence that she provided to your office?
To my office or Fremont County?
Fremont County.
I did.
Okay. And one of the pieces of evidence is exhibit number 16. Judge, I don't see it going up.
all right, counsel, if you'd like, we can take a lunch break, or we can keep moving on here from that.
Here we are, Judge.
Okay.
Okay, and officer, I'd have you turn to the screen and see if you can read the screen. Just read it. Not out loud, just to yourself. Let me know when you're done.
I'm done, sir.
Okay. And I would represent to you that this is a email from Tammy Daybell to her friends in the Salem 3rd Ward of her church. Okay? And would you start with the word something and read the email to me?
Something really weird just happened. I want you to know so you can watch out. I'd gotten home and parked in our front driveway. As I was getting stuff out of the back seat, a guy wearing a ski mask suddenly standing at the back of my car with a paintball gun. He shot at me several times, although I don't think it was loaded. I yelled for Chad and he ran around the back of the house. I have no idea what his motive was, and he never spoke, even after I asked him several times what he though.
Okay. So, and do you see the date on this email? It's just about friends there.
Are you gonna object to this being characterized as an email?
I'll sustain that.
Okay.
Do you want to clarify, Mr. Farr, what type of communication it is?
Well, it's a communication to the friends of the church, and I think it's a text
I'm
message.
sorry.
I can. I believe it's a text message. Judge, I may have misstated that it was an email.
Okay,
My apologies. So this text message went out to all of the friends of the Salem 3rd Ward. It's an LDS ward over in town of Salem, right?
I can't answer
You
that.
don't know. You know where the town of Salem is, right?
I do.
And that's a town that's close to Rexburg?
Correct.
Okay. And obviously, you can't answer that about the ward or anything like that, but obviously the term ward would suggest that it's some sort of a religious group of folks they're talking to, right?
Correct.
Okay. But this email doesn't say that she was shot with a gun, or there's even a mention of a gun. The email talks about a paintball.
Again, I'm gonna object to characterization of this as an email. It needs to be
Text
short.
message, judges, it's gonna be.
I'm sorry. We'll speak for
Yeah. When there's an objection, Mr. Corrigan, gotta have time to get it on the record, make a ruling, and then respond, please. So if it's sustained, this states the evidence.
Text message.
I'm also gonna object to this being described as a text message. There needs to be some foundation for what this evidence actually is.
Judge, I don't need a foundation. This has been admitted as an exhibit. This is
All right.
it.
I'll overrule that objection. Jury can review it in the format it came in with the screen capture.
So at any rate, this message from Ms. Daybell to the people of the third ward doesn't say that it was a gun, does it?
Does say it's a gun, just says it's a paintball gun.
Oh, it says paintball gun. You're right. Okay.
Yes, sir.
It doesn't say any other gun, though, right? If there's any confusion about that, right?
Not in this email or text.
Okay. Did you also have an occasion to look at I'll be bringing that up later, but the search engine from Tammy Daybell's account?
No, I did not look at the search engine for Tammy's.
Were you aware that, and I'm gonna hack his name, but one of the officers, Officer K, whatever his name is, Officer K, was provided email, search information that Tammy Daybell engaged in regarding paintball guns in a picture. Were you aware of that?
Objection calls for speculation.
I'm asking whether he's aware of it.
Overruled.
Are you aware of it?
I was aware that he was provided information. I can't tell you exactly what information he was.
Okay, we'll get to that in another day. But did you also listen to the 911 call that was made regarding the paintball incident?
I did.
Okay, and there was no mention of a gun in that 911 call, right?
No,
The mention in the 911 call is that someone took a shot at me or tried to take a shot with a paintball gun, right?
that's correct.
Okay, so the suggestion today that it was a gun is based on your own hunch, right?
No, sir.
Well, do you have the gun?
I have evidence of Google searches done by Alex Cox around that time.
Okay. Do you have information as to where Alex Cox was at the time of this alleged shooting?
Yes, sir.
You do have evidence of that?
He was at the Daybell residence earlier that day.
I didn't ask you on the day of the Daybell residence at the time of this shooting. And do you recall when this shooting took place?
I believe it was maybe 8 in the evening, maybe.
Right. And let's clarify this because the data that you have regarding him being at the residence was much earlier in the day, right?
That's correct.
And and you don't have any data that shows that Alex Cox's phone dinged or any other communication device that Alex Cox had was at the location of the house at the time of this paintball incident, do you?
At the time, no, sir.
Okay. And so at this point, the information you're talking about is there's some Google searches by Alex Cox, correct?
That's correct.
And the information is that you've decided to not take into consideration Tammy Daybell's own statement about a paintball gun?
Objection misstates his testimony.
Sustained.
So what other information are you leaning on to suggest that this was anything but a paintball gun?
The Google searches performed by Alex Cox talked about shooting through Dodge Dakota.
Okay. And I appreciate that. And that would be one of Chad and Tammy Daybell's vehicles. Is that correct?
That's correct.
Okay. Were you aware of who was driving the Dodge Dakota at the time that incident took place?
No, sir.
Okay. Did you talk to any of the family members, any of the 4 children about who was actually the driver of this Dodge Dakota that Alex Cox was trying to figure out a way to shoot through?
We attempted to contact those children and they wouldn't speak with us.
Okay, so you don't know whether Chad Daybell or Tammy Daybell were driving that Dodge Dakota, right?
That's correct.
So the reality is that Tammy Daybell was driving the Dodge Dakota. It sounds like Alex Cox had something for Tammy Daybell. Is that what you're suggesting?
I'm not suggesting that. I'm just simply stating what Mr. Cox's Google searches were around the time of that shooting.
Okay, and you're basing those Google searches on your position that you believe this was a shooting, right?
That's correct.
Okay, so if Chad Daybell was driving the Dodge Dakota during this time, and he was the primary driver and maybe the only driver, would that mean then you would be looking at whether Alex Cox was trying to shoot Chad Daybell?
Chad Daybell didn't call in a 911 call and said he was shot at Tammy Daybell.
Yeah, but Tammy Daybell called in a 911 call about a paintball gun. And it was a paintball gun. And we'll have Officer Cannon talk about that. And we'll listen to the 911 call.
Objection, that's not a question.
Well, the question is,
Mr. Pryor, again, you've got to give me an opportunity to rule an objection. If it is sustained, it's just argument, it's not a question, you can ask another question.
the shooting and the call that was taking place was in reference to a paintball gun incident, wasn't it?
Can you repeat the question, sir? I couldn't hear you.
The call that was made regarding this incident was a 911 call about a paintball incident, wasn't it? They used the words paintball in the 911 call, didn't
That's correct.
they? We'll move on. Okay. Now, we previously talked about, and Judge, I don't know when you want to stop, I've got a ways to go.
I think this probably is a good time for the lunch break, even the time. So we will take our lunch recess, that will be an hour. We'll plan on coming back on for additional testimony around 10 and quarter after 1.
All rise, please.